Now, at least 330 cats are feared to have died from a mysterious illness called Feline Pancytopenia, which is linked to recalled pet food, and many more cats have become ill. In fact, the Royal Veterinary College warns that the true number of cases could be a lot higher because many vets aren't actually diagnosing this illness. It's very rare, and of course many cats who become ill aren't necessarily being taken to a veterinary practice. Now, for many people, a cat is an integral part of the family and may sometimes be their principal companion. I'm very conscious it's a little morbid, and I apologise for that, but I do want to discuss whether you would have a claim if your cat's been ill or if your cat has died because of something that's wrong with its food. And to explore the issue with me is Phil Tansley, a partner at Shoosmiths solicitors. Phil, I want to talk about potential claims against the cat food manufacturer and also potential claims against the store that someone buys their cat food from. Let's start with the cat food manufacturer. Could the manufacturer be liable to compensate owners in court? Good evening.
Evening, Daniel. The short answer is yes, the manufacturer could be liable. There are two sorts of liability that could face manufacturers. The first is in negligence, and the second, which is more likely in a case like this, is under the Consumer Protection Act.
That's the Consumer Protection Act 1987. Can you just explain what that says?
That's right. So Section 2 of the Consumer Protection Act 1987 essentially says manufacturers or parties who hold themselves out as the manufacturer, and we'll come back to that in a moment, are liable to, on a strict liability basis, to compensate consumers who have bought products that may cause harm to either themselves or to their property. And in the eyes of the law, a cat is your property.
Now, you said strict liability. Just explain what that means.
Well, for a lot of claims like negligence and causation, what you need to do is prove breach of a legal duty. The Consumer Protection Act makes things a little bit easier for consumers because all you need to do is show that risk of harm. You don't need to show, for example, that the manufacturer knew that there was a problem with their product.
What about claims against the retailer, the shop or the store where somebody bought the cat food from?
Well, if you buy a defective product from someone, then you're going to be liable in contract in most cases. Under the Consumer Protection Act, you're also liable if you hold yourself out as the manufacturer. So whilst I don't know the details of these cases, what I do know is that some of the cat food was own label product. So in those cases, if it wasn't obvious to consumers that the cat food was manufactured by someone else, they might have a claim under the Consumer Protection Act against the retailer.
And what about a claim, you mentioned a claim in contract. I think that would be helped by the Consumer Rights Act 2015, which is a slightly different piece of legislation. What does that say?
That would. That gives enhanced rights for consumers, and it would also, in a case like this, give things like an automatic right to a refund for property which has been recalled.
And the Consumer Rights Act says that the stuff that you buy from a shop has to be of satisfactory quality and fit for its purpose. I think it's probably quite self-evident, Phil Tansley, but would food qualify?
Exactly. That's an implied term under all contracts. So I think if there's any evidence that the food is toxic or causes harm to cats, then there's plainly going to be breach of that obligation. I think the issue here may well be more a case of showing that the link generally between the products and the condition that's facing cats, because at the moment, obviously, there's a lot of circumstantial evidence, but what isn't, as far as I'm aware, in the public domain is clear scientific evidence explaining how the products came to be contaminated and how that led to the condition in the cats.
For somebody claiming against the manufacturer or the retailer, they'd have to prove, is this right, that it's just more likely than not that the food was the cause of the feline pancytopenia?
Exactly, and generally in cases like this, often it's quite difficult for a consumer to prove the exact cause of loss, so that the courts are generally quite generous in finding that there's a causal link that the law looks for.
And given my understanding is that feline pancytopenia is a very rare disease, if the fact that a lot of cats that eat a particular food are coming down with this very rare disease, would that be enough to make it likely on a balance of probabilities that the cat food was the cause?
I think it's likely to be, but there is some doubt around that. I think what is likely is if well-funded claimants are able to bring forward claims, then they're probably going to be quite capable of getting together expert evidence that will prove the causal link, or by the time those claims come to court, obviously there are a lot of regulatory investigations going on into what happened, and they may well provide the evidence that claimants need.
How would compensation be calculated? How much money would someone get?
Well, all of the various causes of action I've talked about give damages on a compensatory basis. And English law looks at compensation purely in terms of financial loss. So in cases like this, I mean, you may well find you'd be able to recover the vet's bills, or if you've got insurance, at least your insurance excess. You might have wasted time, for example, taking time off work or a taxi to the vets. And you know, if unfortunately your cat has died, you may have a claim for the cost of a new cat. But you know, what might seem surprising to your listeners is that there is no claim apart from in extremely unusual circumstances for the distress and suffering that you know, you may have suffered seeing your cat get ill and possibly even unfortunately die.
Philip Tansley is a partner at national law firm Shoosmiths, specialising in product liability claims. Philip, thank you very much. And if you are unfortunate enough to have a cat who's become ill as a result of any foods, I believe that there are some law firms that are putting together group actions which will avoid the need for any individual to have to fund the cost of an action yourself, but you will need to find details of those firms by searching on the internet.